Risk assessment and trustee liability cover trustee training. Circular PF 130 represents the FSCA's interpretation of various issues and requirements in respect of corporate governance. The PF 130 proposes that a fund's code of conduct incorporate an education and training policy, and therefore requires that trustees complete rigorous and comprehensive training on various matters. This training aims to provide trustees with information that they can use to identify and assess areas of risk, as well as information on methods to manage these risks once they have been identified. The training will then go through the concept and purpose of the trustee liability cover and how trustees may go about determining a sufficient level of cover. It is important that trustees have the necessary training to keep up to date with ever-increasing compliance requirements, as well as the skills which enable them to apply their mind to various matters and deal with them according to the fiduciary duties imposed. There are various areas of risk that a fund and therefore a board of trustees may face. These risks need to be categorized and managed as far as possible. As a starting point, risks can be separated into two broad categories. Internal risks, such as fraud, dishonesty, negligence of a trustee, errors in the fund rules that expose a fund to additional risk, and members committing fraud. Risks could also be external, such as contractual risks, which would be exposures from contracts with administrators, consultants, auditors, etc. Risks relating to the employer or participating employers, as well as investment risks. Not all risks will be insurable or even directly manageable. However, it is important that trustees apply their mind to the concept of risk management as best they can in order to identify areas of exposure. Only by identifying potential risks or areas of exposure can trustees formulate sufficient internal controls to manage these risks. This will also assist in determining a sufficient level of cover. There will always be an element of the unknown or unforeseen risks, but identifying risks where possible will minimize the portion of unknown risks. It would also be wise for risks to be categorized from small to large in an effort to identify which risks are actually tolerable, which means they exist but are part of the fund's activities and are easily managed. Risks that are identified as being intolerable will then have to fit into three subcategories, namely, risks that are covered by the fund and trustee liability policies, risks that are not covered by the fund and trustee liability policies, and risks that cannot be defined or identified. Once trustees have gone through some sort of risk identification process, they should then set out a risk matrix. The matrix should identify the source of the risk, classify the risk, specify the details of the risk, rank the risk according to its probability of occurrence and the potential impact of the risk, set target dates for resolution of the risks, and allocate the management of the risk to appropriate parties. The trustee should then establish a program of action and reporting for all of the items included within the matrix, and then include this matrix as part of the fund's risk management policy. What is trustee liability cover and why is it needed? As the fund is a separate legal entity from the employer, trustees can be held jointly and severally responsible in their personal capacity for loss of assets of a fund. Trustee liability cover is a form of insurance that provides cover for any legal liability and/or direct financial loss which arises in the event of any actual or alleged wrongful acts, negligence, and fraud by an officer of the trust or fund. This cover essentially protects trustees from being held liable in their personal capacity. Overall, there is little guidance on what insurances retirement funds are required to have, other than fidelity guarantee insurance, which is specified in Section 32U of the Pension Funds Act. Regulation 32U of the Pension Fund Act stipulates that the fund must have a policy of insurance to indemnify it against loss due to dishonesty or fraud by any of its officials. The fund's auditor will check on an annual basis that this policy is in place. Most policies will include cover for claims involving alleged negligence, a wrongful act or breach of duty, claims for theft, fraud, and dishonesty, as well as claims for third-party cybercrime, which protects the funds from outsider fraud via the insured's computer system. It is important to note that this does not cover human error or manual data breaches. In terms of POPIA, a responsible party would still be liable for any breaches which occur in the processing of personal information. However, protection against these types of incidents would also be offered under a professional indemnity, also referred to as a PI policy, which is why it is crucial to make sure that the parties who contract with the fund have sufficient levels of cover in place at all times. What should trustees consider when applying for cover? Some things to take into consideration would include the size of the fund, how many members, as well as the value of contributions, the risk profile of the fund, the service providers contracting with the fund and the level of protection offered via the service level agreements, the number and calibre of trustees, the rules of the fund and level of protection offered by any indemnity provisions included, as well as the fund's level of compliance with the FSCA and PF 130. What is considered as sufficient cover? Schedule B to the financial statements, also referred to as the Statement of Responsibility by the Board of Trustees, states that the board must confirm that they ensured adequate fidelity cover was maintained in compliance with the rules of the fund. The laws and governing authority of retirement funds have not provided any guidance as to what the formula should be in order to ensure adequate cover. This means that the sufficiency of cover is ultimately a trustee decision. Some common suggestions or options in the retirement fund industry that a board of trustees may opt to use as a formula for sufficient cover are 2 times the largest death benefit, a percentage of assets, usually 10% is used for this formula, or several months contributions, or a minimum cover of 1 million rand. The current cover in place for most of the funds that Tenant administers is based on the 10% of assets formula. These policies are reviewed annually to ensure that cover is still sufficient to the best of the trustee's ability. Claims events against the trustee liability policy are generally unlikely, which is one of the reasons that the cost of cover is relatively inexpensive. Because of the lower cost, it is recommended that trustees err on the side of caution when it comes to setting the cover limits, even at the risk of being slightly overinsured. However, each fund is different and the trustee should bear in mind the unique considerations and risks applicable to their particular fund. Claims against the policy. Each policy needs to be carefully read and understood, as the potential claim events and amounts will be specified in the policy. There are many variations between policies, but generally, these main categories should be understood and noted. Fund losses due to crime, such as theft or fraud, cyber attacks causing data loss, the reinstatement of data, legal costs, the reinstatement of cover, losses incurred due to the negligence of a fund officer, and arbitration costs. As soon as the board or an individual trustee becomes aware of a potential issue that could become a claim, an obligation exists for notification to the policy issuer, or at least the broker thereof, of a possible claim. This will enable the insurer to open a file in anticipation of a potential claim. This action carries no burden for the trustees, and the file will remain open until either the claim is actioned or the board of trustees informs the insurer that the problem has been resolved or is in fact a non-issue. Important notes relating to the notification of a claim. Once a claim is made, the board must notify the insurer. Following this notification, no further action should be taken by the board, as the policy would provide for the right of subrogation to the insurer. If the board contacts any outside legal service, the insurer's right to subrogation will be prejudiced and the claim may be repudiated. For context, subrogation is the act of one party assuming the place of another party's legal right to collect a debt or damages. This means that if an insurer would pay out a claim, they then have the right, in place of the policyholder, to recover debt or damages directly from the party whom the claim was made against. The board must not admit liability for any claim made, as this will compromise the policy and may lead to claim repudiation. If the board fails to notify the insurer and a claim is realized, the insurer may repudiate the claim. Choice of insurer and common policy exclusions. Over the past few years, there have been a few issues which have impacted negatively on the retirement fund industry, resulting in an increased number of claims being reported to insurers, which has caused them to become more risk adverse. Numerous insurers have withdrawn from providing quotes and cover to retirement funds. Limited cover is provided by SHA and AIG, but consistently the most favorable provider in the market is CAMAG. CAMAG is the carrier for the majority of the funds under tenants administration, with Van Flyman acting as the brokers when it comes to trustee liability cover. Common exclusions on CAMAG policies are as outlined on the list below. We will focus on the ones which are most relevant in a retirement fund context. There is an exclusion arising from investment performance. However, any loss arising from the failure to execute a specific investment transaction would be covered by the policy. Loss arising from the employer company intentionally suspending contributions, fraud committed after the insurer is aware of any dishonesty or fraud by an officer will also be excluded. Loss where indemnity is covered under another policy, such as a PI policy. For example, certain kinds of data breaches are not covered by a trustee liability policy, meaning that the retirement fund and ultimately its trustees would still be liable for any breaches which occur in the processing of personal information. However, the administrator that the fund contracts with should have a professional indemnity policy in place which could offer a level of protection. Loss in respect of surplus apportionment or distribution. However, any legal costs relating to this would be covered. For example, if a claim relating to surplus apportionment was made against the fund and taken to the pension fund adjudicator, an ombud or court of law, and the fund incurs legal costs in defending the claim, these costs would be covered. However, if the fund was ordered to pay out a surplus portion owing to a complainant, this would not be covered under the policy. Failure of computer and allied equipment or losses as a result of virus attacks would also not be covered under the policy. Overall, most of these exclusions are standard and do not in any way compromise the cover that a trustee liability policy is intended for. Trustees can be assured that the wording of all policies is wide and fair, allowing insurers to respond to legitimate claims. The trustee liability cover renewal process. The funds which we administer all have trustee liability cover in place. The policies are renewed on an annual basis. A few months before the renewal due date, usually 1 to 2 months before, the insurance broker sends through the trustee liability renewal proposal form. The tenant legal team then completes the relevant information using the fund's annual financial statements and previous policy, and then sends this through to the trustees or principal officer for review and signature. It is very important when the principal officer and trustees review the renewal proposal form that they disclose any changes in material risks to the fund. The details of any material risks need to be included in the renewal form. Changes in material risks would include things like an increasing number of complicated death claims, employer debt, or changes to the liquidity status of the employer. The signed and completed proposal then gets sent to Van Flyman along with a copy of the latest signed annual financial statements. The insurer, which is CAMAG in most cases, will then issue a quotation which will need to be signed by a trustee or principal officer as proof of acceptance. It is important to note that trustees must sign the quotation within 30 days. If they do not, a no-claim declaration form will need to be completed and returned along with the signed quote. The signed quotation is sent in and an invoice is issued along with a copy of the renewal policy. The final invoice will be paid by the fund and the cover will then be renewed for another year.